everyone, and welcome to the launch of issue 41.1 of the University of New South Wales Law Journal. Thank you very much for being here. I'd like to begin by acknowledging the Gadigal of the Eora Nation, the traditional custodians of the land on which we meet, and pay my respects to their elders past and present. And I acknowledge also the considerable work done and being done by members of our faculty, students of our law school, in many projects connected with the ongoing aims of truth, recognition and reconciliation. Well, it's always a wonderful event, the first launch of the year. For many years now it's been hosted here at Allens, and tonight's is no exception. The journal's work continues more or less unabated over the summer months, but something about seeing a hard copy of the year's volume crystallises the fact that we are well underway and that the publication schedule for this year will be a reality. This year's is particularly exciting for a couple of reasons. The first is that very recently the wonderful refurbishments on the client floor here at Allens have been completed, and we're one of the first groups to grace the new fit out, and it looks fantastic. But the second reason is that the relationship with Allens has reached something of a coincidental numerical milestone. The sponsorship of the journal from Allens has been ongoing for now 37 years. The first issue, I checked the records today, the first issue which Allens sponsored of the journal was issue 41. So it is remarkable and altogether fitting that with a continuous relationship all these years later, it is at Allens that we formally launch volume 41. I want to extend a very warm thanks to Allens and to the team here, Lauren Kay, Steph Marshall, and the rest of their team, and to Tim Stewart for being here with us this evening. But of course, tonight there is someone in particular to thank and to congratulate, and the person who has, via steady leadership, ensured that we have issue 41.1 here to launch this evening, and that is Rose Vassell, the editor of issue 41.1. This year is a transitioning year for the journal as it moves, and Rose, I imagine, will outline this more. The format of this launch and of this issue is different to what many of you may have become accustomed to if you've attended these events in the past. The journal now has renewed its focus on being a leading generalist publication, and this is connected with the launch of the forum, which has recently gone up on a newly designed website. You can find that, if you're so minded, via Google or your preferred device. But throughout the last year, in helping manage that transition, Rose's leadership and creativity has been clear to all of us on the journal, and it has been a great encouragement to me and to the rest of us on the executive committee, and it is in no small part thanks to her that this issue is such a success, as you'll see from the back cover of the issue, and I invite you to collect one from the back of the room if you have not done so already. There's an eclectic and diverse mix of articles in this issue, which demonstrate very clearly the journal's renewed focus on being a publication that is responsive to topical social and legal issues and which publishes the very best scholarly work from all fields of law and legal research and scholarship. So without further ado, I should introduce Tim Stewart, who has been a partner here at Allens since 2015 in the Banking and Finance Division. And Tim is going to welcome you all to the firm and introduce Rose. Thank you, Tim.
Thanks very much, Lachlan. Before I begin tonight, I would also like to acknowledge the traditional owners of the land on which we meet, the Gadigal people of the Eora Nation, and I too pay my respects to their elders past and present. Lachlan stole a little bit of my material, but that's okay, because I was told that I was going to have 20 minutes to stand up here and talk you through the artwork on the new level 28, as well as sort of what we've done in terms of the fit out, the fundamental differences between what it looked like before you got here and what it looks like now. But you'll be pleased to know that I'm not actually going to do that. Look, I have the great honour tonight of, on behalf of Allens, of welcoming you all here, and I would like to specifically acknowledge a number of our distinguished guests that we have in the room, and welcome you all to our offices for this evening's presentation. As Lachlan said, our relationship with the UNSW Law Journal stems back some 36 years. And in addition to being a partner in the banking and finance team here, I'm also an ex-UNSW student. So the relationship between Allens and the Law Journal is over 36 years, 37 years this year, well and truly before my time. And throughout that time period, the vast majority of the time the journal has been operating, Allens has always acknowledged the role of this journal and other journals from other law schools around the country, and respect the role that it plays in framing the legal discourse in this country. Looking again at the index to this edition, it looks to build on this tradition, dealing with some of those issues on what people might call the hard law, from statutory interpretation, the analysis of legislation, through to law and policy, touching on themes that are really resonating in society today, including in respect of some of our most vulnerable people. And I'm sure Rose will go into a little bit more detail about the genesis of these articles and the thrust of the issue, the first issue this year. And really, though, at its heart, this is what the profession of law is, what it's all about. We at Allens deliver legal service to our clients, and we think we do a pretty good job at it, but we are just one segment of the profession. To be able to serve and support the broader profession here in its work and its role in society, as well as the university in teaching those lawyers, up-and-coming lawyers, what it means to be a lawyer, is really key to our ethos here, and we're proud once again to be able to do that this evening by supporting the launch of this journal. And without further ado, I will introduce Rose Vassell, the editor of this first issue.
Thank you, Tim. It is my pleasure to welcome you all to the launch of Volume 41, Issue 1 of the University of New South Wales Law Journal. I will also begin by acknowledging the Gadigal people of the Eora Nation, the traditional owners of the land on which we meet. And I too pay my respects to the elders past and present, and to all Aboriginal and Torres Strait Islander people here this evening. As Lachlan mentioned, this has been a very exciting year for the journal. One of our most significant initiatives over the last 12 months has been to adopt a new publication structure that moves away from the thematic orientation of previous issues. The journal will now publish 3 general issues and 1 thematic issue each year, with each issue featuring a smaller number of articles selected for their potential to make a unique contribution to their respective fields. Issue 41.1 is the first entirely general issue to commence with this new structure. This change to the structure of the journal enables it to better promote the high quality and original general submissions that we receive each year. The calibre of these submissions is best illustrated in the 9 articles published in this issue, which explore a wide range of legal issues that are of great relevance to the Australian legal community. In this issue, Jacinta Dharmananda provides interpreters of federal legislation with a comprehensive overview of lesser-known aspects of the legislative process in her article on the use of parliamentary materials in interpretation. Next, Laura Grenfell and Sarah Moulds discuss the role of scrutiny of bills committees in protecting human rights, focusing in particular on how parliamentary committees across Australia have scrutinised anti-bikie and anti-terrorism and counter-terrorism bills. In his article on law and poverty, Acting Justice Ronald Sackville considers the progress of the Australian legal system in addressing bias against poor and disadvantaged people, and the limited ability of the law to provide a complete solution to social injustice. Kate Fitzgibbon examines Australian media coverage of the Dondale Detention Centre incident in 2016 and concludes that an international human rights perspective assists in understanding and responding to these issues. Tracy Booth's critical analysis of recent changes to the New South Wales Crime Sentencing Procedure Act draws out the likely impact on the use of victim impact statements in homicide offences and the consequences for family victims in the sentencing process. Heather Douglas and Mark Burden address the uses of smartphone recordings in context of domestic and family violence and the challenging evidential issues that arise when courts decide whether or not to admit them. Fiona Levine and Michelle Evans seek to provide clarity and recommendations to universities in their article on the legalities of revoking university degrees for misconduct. Russell Smythe, in his article, analyses New South Wales District Court citations decisions from 2005 to 2016 to draw out patterns in citation. The first such study to consider the citation practices of an inferior trial court in Australia. And the final article on this issue, by Jonathan Liddycote, examines the implications of the US case Akamai Technologies, which considered divided performance of patented methods and compared it with patent law infringement mechanisms in Australia. So, in the spirit of promoting the excellent general submissions that we receive, the journal has selected an article to lead issue 41.1. And this article is Jacinta Dharmananda's Using Parliamentary Materials in Interpretation, Insights from Parliamentary Process. It has been selected as the lead article for this issue for its potential to make a significant contribution to the study and practice of law. The article makes the case for a broader appreciation of the statute-making process in statutory interpretation. In examining the source, purpose, procedure, and timing behind the creation of parliamentary materials, it allows users of federal legislation to better navigate the political and other aspects of a bill's enactment. The topic of this article also raises broader questions of the relationship between the legislative process and statutory interpretation, the role of the judiciary in interpreting legislation, and the use of non-statutory materials. It is these ideas and more that we hope will be explored in the UNSW Law Journal Forum in the months following this launch. In addition to providing the topic for tonight's launch event, the lead article will be the catalyst for a series of shorter, responsive pieces that will be published in a special collection on the forum. The forum, we're proud to say, has recently been launched on our new website and promotes discussion and debate with shorter form commentary on topical legal issues. I would encourage all of you to visit the forum and to follow the special collection on statutory interpretation and parliamentary materials as it develops. This issue of the UNSW Law Journal is the result of the combined efforts of a number of people, to whom all of them I am immensely grateful. First, I would like to thank the authors of the articles featured in this issue for entrusting their work to us. It has been a real privilege to work with them in bringing issue 41.1 to publication, and their good humour and assistance throughout the editing and proofing process were greatly appreciated. I would also like to thank the journal faculty advisors, Professor Rosalind Dixon and Associate Professor Lyria Bennett-Moses, whose input and advice over the last 12 months, in particular in developing the new publication structure, have been invaluable. I am likewise very thankful for the ongoing support shown to the journal by the Dean of UNSW Law, Professor George Williams. Thank you, of course, to Premier Sponsor Allens for hosting the launch event this evening, and to our other Premier sponsors, Herbert Smith Freehills and King & Wood Mallisons. I also acknowledge the anonymous peer reviewers who generously dedicate their time and draw on their experience to provide feedback on each new submission. The thoughtful and considered comments of peer reviewers help us in making publication decisions and help the authors to improve on their own work, both of which play an important role in maintaining the calibre of the journal. None of this, of course, would be possible without the diligent efforts of the journal's editorial board. The talented, capable students on the board have spent countless hours proofing every word and checking every source in these articles. They have gone above and beyond to find and eradicate those sneaky italicised commas. To the Executive Committee, it has been a great privilege to work with and learn from such dedicated, passionate, and interesting people. The last 12 months have been marked by a number of changes within the journal, and it has been wonderful to see how the executive has embraced a more collaborative approach and explored the possibilities opened by the change in publication structure. I'm especially grateful to previous executive editor Justin Carty and current executive editor Lachlan Peake, whose leadership, timely advice and commitment to the journal have made the publication of this issue possible. Finally, on a personal note, I wish to thank my friends and family who have offered great support and enthusiasm over the last 12 months. For this, I am endlessly grateful. It is now with great pleasure that I welcome our keynote speaker for this evening, the Honourable Justice Basten of the New South Wales Court of Appeal. Prior to his appointment to the bench, Justice Basten taught at UNSW, then practiced as a barrister and Queen's Counsel, specialising in administrative and constitutional law, native title, immigration and human rights. He has served as a part-time commissioner of the New South Wales Law Reform Commission, the Australian Law Reform Commission, the Human Rights and Equal Opportunity Commission, and as Assistant Commissioner of the Independent Commission Against Corruption. Please join me in welcoming Justice Basten.
Thank you, Rose, and thank you, ladies and gentlemen. It's a pleasure to undertake this task this evening. When Rose invited me to launch the issue, she sent me a complete set of all the papers that were to be published. And I looked through them with great interest, and I must say that I echo Lachlan's comments that the issue contains a wonderful collection of excellent papers on a really wide range of topics, many of which I had never considered before, but I found intriguing. I also found intriguing that it included a paper by my friend and colleague Ronald Sackville entitled Law and Poverty, a Paradox. In the bundle I was sent, it was just about the last paper. I went next door and asked Justice Sackville why his was the last piece. Unfortunately, he had already received the published version and knew that that was not so. He pointed out to me that it was number 3, not number 10. My mischievous question fell entirely flat, but I must say he was not unusually despondent, or rather unduly despondent. He's usually despondent. But he also expressed his warm approval for the quality of the editorial work, and I thought I should pass that on to those of you who may have worked on it and are present. Actually, his was not even the last of the collection I was sent. There was a paper which complements the one I'm about to speak on, which I should mention, which is that by two Adelaide-based writers, Laura Grenfell and Sarah Moulds, on the role of parliamentary committees scrutinising bills for human rights. Anyway, if you have a copy of the publication, you will realise that the papers are in an entirely logical and appropriate order. But let me turn to Jacinta Dharmananda's paper on using parliamentary materials in statutory interpretation. I think Jacinta Dharmananda has two purposes underlying this piece. First, she thinks, broadly speaking, that those of us who read and construe statutes for a living should better understand how they are created. I have much sympathy for this view, but it immediately reminds one of the adage attributed, apparently mistakenly, to Otto von Bismarck, "Laws like sausages cease to inspire respect in proportion as we know how they are made." Dharmananda's more specific purpose is to encourage an understanding of the sources, timing and purposes behind parliamentary materials which are called in aid in the process of construing a statute, but usually with little idea as to their original provenance. To that end, she hopes we will avoid the stinging critique of the use of such material, also the subject of a well-known aphorism, ascribed to Judge Harold Leventhal of the DC Circuit Court, who once likened the use of such material to entering a crowded cocktail party and looking over the heads of the guests for one's friends. As Antonin Scalia and Brian Garner wrote, after quoting Leventhal, because there are no rules about which categories of statement are entitled to how much weight, the history can either be hewed to as determinative or disregarded as inconsequential as the court desires. As Dharmananda explains, this article is part of a study being undertaken by her for a doctoral thesis at the ANU. I think the project is timely. It is timely because there appear to be tides in the affairs of statutory interpretation. There are peaks and there are troughs. The trough we have recently passed through has been described as the new textualism. It was characterised by a dismissive attitude towards the concept of legislative intention and, concomitantly, limited interest in extrinsic materials. There is some irony in the fact that this last trough arose shortly after Parliament had legislated to ensure that courts could take account of extrinsic material, such as second reading speeches and law reform reports, in construing legislation. Perhaps familiarity with the process of legislating indeed bred judicial contempt, as Bismarck might have predicted. The most cogent dismissal of reliance upon parliamentary materials was expressed by one of your staff, former President Mason of our court in 2008, in Harrison and Melham, in support of the proposition that a minister's understanding of the effect of a statute or the state of the common law cannot give the bill he or she is promoting an effect inconsistent with its terms as construed by the court. He called in aid language to similar effect in Re Bolton Ex Parte Bean, in a joint judgment of Chief Justice Mason of the High Court and Justices Wilson and Dawson. As President Mason, himself a former Solicitor General, noted, these three justices were former Solicitors General, who may perhaps be taken to have had some awareness of the capacities of busy ministers seeking to expound a bill and or persuade the Parliament to pass it, to be prone to the gamut of human imperfections to which we are all subject. Although she does not directly refer to these observations of the then President, Dharmananda does refer, in a footnote I add, to a passage in my judgment in Shorten and David Hurst Constructions, in which I questioned aspects of the reasoning in Harrison and Melham. I note in passing that Pearson-Getty's statutory interpretation in Australia refers to Harrison Melham but not to Shorten. Perhaps it's not only judges who survey the crowded room in order to select their friends. I realise that in speaking of peaks and troughs, I have strayed into an implicitly value-laden image. If I say that, led by recent decisions in the High Court, we are coming out of the trough, I may be understood as implicitly approving a change in course, despite the fact that the image of a tidal system conveys a degree of inevitability. However, let me make my approval explicit. And in doing so, I do recognise that there is always scope for scepticism about the value of the exercise. But I think we have been through a Humpty Dumpty phase. You all know the passage in Alice in Wonderland. When I use a word, Humpty Dumpty said, in a rather scornful tone, it means just what I choose it to mean, neither more nor less. The question is, said Alice, whether you can make words mean so many different things. The question is, said Humpty Dumpty, which is to be master? That's all. The dismissal of legislative intention as a fiction allows the court to be master, to determine the meaning of the text with little regard to what was done or said in Parliament. Of course, the judge is not being Humpty Dumpty. He or she does not choose the words. Parliament does. But the court decides the meaning. As we all know, context is everything. In principle, it is difficult to justify an approach which imposes strict limits on what the court may take into account in construing legislation unless we diminish the role of Parliament. That is not to say that there should not be limits, and further, that pragmatic considerations are not relevant. They are, of course. It does suggest, however, that awareness of the imperfections of the parliamentary process might suggest the importance of improving one's general understanding of that process rather than rejecting its product on the basis that it sometimes may be flawed. I think that Dharmananda would say that the insights enjoyed by former Solicitors General who are appointed to the bench should be more broadly shared and more rigorously applied. An understanding of parliamentary process is a highly desirable backdrop against which to understand how, in general, legislation is processed. For example, there was a report in the news this week that the clerks of the Senate and the House of Representatives had made submissions to a parliamentary joint committee on intelligence and security inquiring into the Foreign Influence Transparency Scheme Bill 2017. Who invented that name, I wonder? A bill designed to expose lobbying and possible interference by foreign governments. Dharmananda seeks to explain the process by which bills are referred to particular committees, at what stage such a referral may take place, the makeup of the committee, and the procedure it adopts, including the cases in which it may call for public submissions and conduct hearings. And of course, other forms of extrinsic material may be important. That is especially true of law reform reports, and the more so if accompanied by draft legislation, as is now common practice. The use which courts make of such reports is quite variable. About 4 years ago, our court and later the High Court had to consider various aspects of the Foreign States Immunities Act 1985, a Commonwealth statute, in a case called Firebird Global Master Fund and the Republic of Nauru. The Act was a product of a report by the Australian Law Reform Commission. The report was unusually authoritative. The Commissioner in charge was then Professor James Crawford, an international law expert. It was accompanied by draft legislation and even a draft explanatory memorandum. The Act drew closely to the draft legislation. Unsurprisingly, all judges in both courts paid close attention to the report. However, that is not always how law reform operates. An intriguing piece of history is to be found in a recent article by Professor Paul Mitchell from Cambridge of the manner in which the UK Law Reform Contributory Negligence Act 1945 was prepared, that being legislation which was the basis for the 1965 Act in this state. The need for reform of the law with respect to contributory negligence led, at the suggestion of Lord Wright, himself one of the judicial critics of the then present law, to the establishment of a law revision committee, chaired by, of course, Lord Wright, and involving eminent experts Stalabras, Winfield, and Goodhart. The outcome was not in doubt. The defence was to be abolished in favour of the current scheme. The drafting, nevertheless, has given rise to difficulties for over 50 years. Professor Mitchell noted that the Law Revision Committee did not produce a draft bill. He continued, "Within each of the official stages of law reform was a small group of individuals representing a small minority of those entitled to contribute, whose ideas and influence carried weight. Furthermore, each stage of the process was not of equal importance. The parliamentary stage, which we might expect to be crucial, was in fact a sterile formality. Key individuals made sure that it stayed that way. Being a consultant to the parliamentary draftsman, by contrast, was an apparently marginal role that, in fact, was just about the most powerful position in the process. The theory of how law reform should occur," he said, "bore no relation to what actually happened." Now, although that experience may be somewhat dated, it should not, I think, be assumed that there are not echoes in contemporary experience. Of course, most legislation does not emanate from law reform commissions, but is prepared within the government with varying degrees of outside input. That can be true of substantial legislation as well as more mundane reforms. Let me give you two examples. The drafting of the Native Title Act 1993, the Keating government's response to the Mabo decision, was assigned to then Attorney General Gareth Evans. He conducted a process in Parliament House of consultation and negotiation with Indigenous leaders from across the country. In the course of one fraught session, Evans was convinced by the late Ron Caston QC, who was the primary legal advisor to the Indigenous leaders, all of whom I might say were in the room, that a particular provision was essential to protecting Indigenous interests. Politically, however, Evans saw difficulties. He told Caston that the government might be able to accept the proposed provision if its purpose could be made less obvious. He adjourned the discussions to allow the lawyers to come up with a more acceptable draft. As Caston was toying with the language, he remarked, "One day I will be before a court seeking to rely on this section, and the judge will say to me, 'Mr. Caston, is it possible that the drafter could have made the meaning of this provision more obscure?' I will reply, 'No, Your Honour, we tried, but we could not.'" The government accepted the result. In his judgment in the Wick case, Justice Gummow stated, although not in relation to the native title legislation, "I begin with the proposition that for a statute such as the Queensland Land Acts to impair or extinguish existing native title or to authorise the taking of steps which have that effect, it is necessary to show at least the intention manifested clearly and plainly to achieve that result. In this context, intention does not refer to any particular state of mind of the legislators who may not have adverted to the rights and interests of the Indigenous inhabitants. Moreover, statute law may be the result of a compromise between contending factions and interest groups and of accommodations between and within political organisations which are not made public and cannot readily be apparent to a court. The Native Title Amendment Act 1998, which followed the Wick decision, involved an even more extensive process of consultation and negotiation than did the original 1993 Act. Perhaps because the then government was perceived to be less friendly, the leading Indigenous organisations combined to form the National Indigenous Working Group. The NIWG hired a number of lawyers, of whom I was one, and a former parliamentary counsel to negotiate with the government over almost every clause of the lengthy bill and to propose alternative and additional provisions. As I recall, the process took some 6 months. The negotiations encompassed not merely government officers, particularly Robert Orr QC and Philippa Horner, who exhibited the highest level of professional responsibility, but were also undertaken with representatives of the opposition, again Gareth Evans, and the minor parties who between them controlled the Senate. Whether, as promised by the then Deputy Leader of the government had delivered bucket loads of extinguishment is for others to judge. The process and the compromises reached could never, as Justice Gummow correctly noted, be conveyed to a court construing that complex legislation. With these somewhat random remarks, I commend Jacinta Dharmananda for her valuable article. I commend the editors for the excellent work they have put into the preparation of this issue. Volume 41, issue number 1 is duly launched, and I wish it bon voyage. Thank you.
Well, thank you. My name is George Williams. I'm the Dean of the Faculty of Law. It's my job to round out the evening before we release you back to your drinks and your food. I'd like to begin by thanking Allens. We're really proud of the partnership we have with the firm. Thank you, Tim, for speaking tonight. The fact that the firm has sponsored the Law Journal for 37 years is remarkable, and it just shows the depth of that relationship as well as its longevity. But beyond that, the firm also provides support to our Law Society, our social justice programs. Many solicitors, lawyers at Allens contribute, whether as volunteers or in many capacities, to things we do. And of course, most recently, we're really proud that Allens has joined us in launching the Allens Hub for Technology, Law and Innovation, which is the most exciting development in this field for many years, and we hope will be a world leader when it comes to developing solutions, new ideas, to understanding how technology is going to change the law. I'd also like to thank the many students who are here who worked on this journal. I know what a formidable exercise it is to produce each one of these issues, and how the arguments can extend over footnotes, minor points of punctuation, how people can bond over style guides late at night. It's a remarkable process that produces a work of incredible quality, and there is fierce competition today within the law journal market, as there should be. As an author myself, people think long and hard. Where do they put their precious publication? And it's wonderful for us that a place of pride and choice is the UNSW Law Journal, as it has been for many years, and the current students are the custodian of that at the moment, but it's a really proud tradition that is being so well maintained by Rose, Lachlan and indeed the full complement of people involved in the issue. It's very good to say that as a law school, now ranked top 20 in the world, we have a law journal that befits where we are in the world, and the innovation also that Rose and the team have shown is really continuing that through the advanced issues, through the restructuring and the like. It's a journal that continues to move as it needs to with the times. And finally, I'd like to say thank you to Justice Basten. And we're very fortunate over many years to have such a strong connection with the judge. We're proud of the fact that he taught our first graduating years back from 1974 to 1982. We're proud of the fact that he had such an illustrious career at the bar. I was very fortunate myself on one occasion to appear as his junior in a case called Appler that we still teach in constitutional law. And we're also very fortunate that he over many years has been so generous in supporting our law school, our journal, through a member of our Law Advisory Committee, and also through championing in particular the need for us to make sure we educate in statutory interpretation and making it clear just how fundamental that skill is. And indeed, many changes that we have made over recent years in public law and other subjects really follow the lead and the thoughts that John has had on that topic. So thank you, Justice Basten. We appreciate your excellent, if somewhat random, thoughts. Of course, they displayed anything but in their delivery, and it was a very coherent, interesting message about what we can learn from some of those anecdotes and really what they say about the place of statutory interpretation and the elusive quest for parliamentary intent. So thank you to the authors who are here tonight. I'll pass that over to Lachlan, but it's been a great night, and I'm glad to see so many people have come to celebrate the launch of this important issue.
Well, thank you, George. That brings the formal component of tonight's proceedings to a close. I too would like to thank Justice Basten, but also George and Tim for very generously giving up their time to be with us here this evening. I think these are some of our best numbers in a while, and I think that's in no small part thanks to the topic and to the speaker. Please do hang around briefly. I can see, there's very few. There might be a rush on the journals, but there are still some. They're not journals. All right, they are Alan's clerkship brochures, and you should, and I commend them with equal vigour. But you can find a copy of the journal in the usual places online. Thank you very much for being with us, and enjoy the long weekend.